Welcome to Cordell Cordell's Men's Divorce Podcast, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Welcome to our Men's Divorce Podcast. The purpose of the podcast is to educate you on interesting family law topics and not provide legal advice. To obtain legal advice, please set up a virtual consultation with us. To do so, call 866-DADS-LAW or visit our website, CordellCordell.com. I am Jerrad Ahrens. I'm a management partner with Cordell Cordell out of Omaha, Nebraska. Today, we will be discussing contempt of court, an interesting and all too common topic. One of the primary purposes of family law litigation is to create court orders that must be followed by the parties. What happens when a party fails to abide by the orders? What are the options for recourse? With me today is Miss Bennita Bullett, Senior Lead Litigator in Raleigh, North Carolina. Bennita is here to discuss your options when it comes to contempt and recourse against opposing parties that fail to follow the court orders. Bennita, why would someone file for contempt of court?
Hello, Jerrad. So yes, just imagine after you've retained counsel in an initial proceeding, you spent thousands of dollars on the proceeding to get a final order, and then there is a party or co-parent and ex-spouse who is not complying with terms of the order. That's when a contempt proceeding will be filed. So contempt, it's a term that's used to describe a situation when a party is not complying with or its terms. So I've seen this filed, or I've filed these contempt proceedings against someone who, for example, is not paying child support, right? They're not complying with those child support terms. Or there may be a alimony claim that they are to pay X amount a month, and that person does not do that. All too common, and sadly, there are parents who will not comply with a custody visitation schedule. So that means the other party is not getting their court-ordered visitation time. Again, that would be an instance where a contempt petition or proceeding would be required and necessary so that that order is complied with. It's so many examples, Jerrad. Another one could be decision making, right? Where in an order, both parties equally share in the medical or educational decisions regarding the minor child or children, and then you have one parent who unilaterally makes those decisions. So that would be another example of when a contempt proceeding is appropriate.
I know when I'm consulting with prospective clients on this issue, that's the option, right? The opposing party is not following the order, so that contempt is the option. If you fail to do that, nothing's going to change. If anything, it might get worse. They might become empowered by failing to abide by this, and then they're never going to follow it. So contempt's the option. Tell us about the two types of contempt.
Right. So it's very important first that you refer to the statute regarding contempt. I know every state has a very specific statute regarding contempt, but there are two types of contempt. One type, a common type of contempt, it's civil contempt, right? And then there is a second type, criminal contempt. Both are very important types of contempt, but they have differences, Jerrad. And this is very important because there are different punishments and ramifications and different burdens for each type. So, for example, civil contempt, that is used to make someone comply with an order. So those examples I gave, when you have a mom or dad that's not allowing the visitation, then, of course, you would want to seek civil contempt for that to make them comply with an order. Also, with civil contempt, there must be what we call purge conditions. So if the court orders that they're in contempt, then the court will give certain conditions. You must do A, B, and C in order to purge that contempt ruling. And if you don't do it, then there can be a sentence. Also with civil contempt, the burden of proof is by the preponderance of the evidence. So it's a very low burden compared to criminal contempt. Now, when you seek criminal contempt, then the burden of proof is beyond a reasonable doubt, a very high burden when compared to civil contempt. Also, with criminal contempt, that's used when there has already been a violation, right? You're not necessarily asking for compliance, but because that person did that non-complying behavior, now you want the court to issue some type of criminal contempt and some type of punishment and ramification for that. And so again, they're very state specific. And I always tell people, when you file your pleading for the contempt, it is very important that you specify which contempt that you want the court to find that non-complying party in, whether it's civil or criminal. So again, two types: civil, criminal contempt that a court can use to make someone comply with an order, or punish someone for non-compliance of a court order.
Okay, so I practice in Nebraska and Iowa, and criminal contempt's not really a thing. So can you tell me, or tell our listeners, how do you determine what you're going to file, whether it's civil or criminal contempt?
I think you hit it right on the head, right? So if in your state that it's like rarely used or unheard of, or some judges just don't like criminal, right? Especially with family law judges, they feel their realm or boundary is civil. And so that's what I would say to someone like, let's say, for example, in North Carolina, you can do civil or criminal. But let's say before the proceeding, you filed for the civil contempt, but now the person is complying. Maybe then you would want to do a criminal because they violated the order, but now they're complying with it. So you don't necessarily need that civil. But again, it's very state specific and statute specific. So you need to make sure that the elements in a civil contempt proceeding can be met, and the same for criminal. And again, you would just need to know the judge, what necessarily their precedents are, and then the state. Like you just mentioned, Nebraska criminal, it's not a thing. So of course, then you would just file for civil contempt.
Okay, and we talked about purging that contempt. So let's say we bring the contempt action. There's a purge plan. We would call it a purge plan here in Nebraska, and they fail to comply with that purge plan. Then what's the next step?
Great question, Jerrad. So the next step should be outlined in that contempt order, right? And so, for instance, if you didn't pay child support and you owe a lump sum of $3,000 as that contempt punishment, the court can say, we will give you 10 days to pay that $3,000. And then if you don't, then you'll be taken into the custody of the sheriff. So it could be jail. And that next step should be specified and outlined in that contempt order, that purge condition. So if it's not purged, and typically there will be a court date set for review to see if you have complied with that purge condition. And so then, based on that review, if you have not complied, then it will let everyone know what the next step is. And typically that's jail.
And that kind of touches on the next thing I wanted to talk about. Filing the contempt, what are you trying to accomplish? What's the relief the court can grant, or what's the punishment a court can order an opposing party?
Right. So, of course, everyone wants everyone to comply with the term, right? Typically, that's what a party wants the court to order that non-compliant party to do. Please follow the term, enforce the term. That's typically at the top of the list. And then also, though, because that person has not complied with a court order that, should be already complied with without a contempt proceeding or being told to do so, you may want to be reimbursed for your attorney fees for having to file that contempt proceeding. That's an option. Another option could be if the party has not complied with the visitation schedule, maybe having some makeup visits. I've seen that. Let's say, you had planned a trip during your court order custody time. And so you incur fees like the flight for the child, maybe a ticket to a Disney park. Those are things that you should be asking and seeking relief for that non-compliance and contempt. A lot of times, Jerrad, I've had egregious cases where people have filed multiple contempts. And so the only bottom line and actual equitable recourse is jail. I don't necessarily advocate for it. However, there have been situations where, parties just will not comply with court order, on top of court order. And so the only relief to make that person understand that you must comply and that we can't keep being out in and out of court is jail time. So that could be a relief. A lot of times, Jerrad, people think that a form of punishment should be a modification of the order. And so that's not a remedy for contempt, to modify the order. I do encourage people, though, that maybe you can do a motion to modify the order based on the contemptuous behavior, but modification of the order should not be a form of punishment for that contempt, if that makes sense. A modification can help, especially if that judge has heard that contempt proceeding and then, rolls it into a modification, because now that judge is already angry and they won't straightforward say, I'm modifying this order because of the contempt, but that can be used to encourage a judge to modify an order when you have a party that just refuses to comply. So there are lots of remedies and punishments for the contempt.
Yeah, a few things you touched on. Attorney's fees. A lot of prospective clients, we talk about contempt. They're like, hey, look, I don't want to go back to court. It's too expensive. I can't afford it. Right. And then we ask for attorney's fees. And if the opposing party is found in contempt, typically those are awarded to some degree, varying degrees. But that helps, relieve people of that concern. The jail time is a possibility. A lot of times courts are going to see it as, if it's a failure to pay alimony or child support, jail time is not going to help the situation, right? It's probably going to make it worse. Then they can't work, or they lose their job because they didn't show up for work because they're in jail. So that's usually worst case scenario or last resort. They'll put them in jail. But I liked how you talked about modification and how it applies to contempts. They're different. They're different lawsuits, or they're different cases. But it's not uncommon where I've advised clients, let's start with the contempts, get some contempt findings, 1 or 2 or 3 or however many, and then we use that for the modification, right? And then we can show the court, look, there's been a material change in circumstances. The opposing party is just not complying, not following the order, and that's grounds for modification. So sometimes you want to start with that contempt, and use that going forward, like you kind of said. And then the judge is already upset. He's upset with the opposing party. Now is the time to strike to get this thing modified. All right, let's talk about common mistakes on contempt cases and why you might file one of those and it's not successful.
Right. And so, Jerrad, this is where I always like to start with someone if they come and consult and say, hey, look, the other party is not complying with the order. I want to file contempt. The very first thing I'll do is say, let me see the order, right? Mm-hmm. Let's read and review the order. And commonly what I am finding, and I know this is probably across the board with other attorneys, is that the terms of the order are very ambiguous, poorly written orders. An example of this would be the parties share joint legal custody. And I just see that one sentence, right? Well, what is joint legal custody? Is that medical? Some people mistake that for extracurriculars, right? And I've had many judges say extracurriculars, it's not outlined here. So how would a party know that that's a decision that must be, mutually agreed upon by the parties? So a lot of times, a lot of these court orders, when they're finalized from that initial proceeding, they are so loosely written. There's lots of gray area. So you need orders to be specific. I've had people come in to do a consult and they say, they're not complying with the order. I'm not getting phone time. and I look through the order and there is no phone schedule. So a lot of times people aren't even aware that when it's contempt, it has to be language in the order, specific language in the order where there's no wiggle room, no room for error, no room for a defense of, well, mistake and, ambiguity. I interpret it this way, so it can't be intentional or deliberate, which is required for a court to find someone in contempt. So that's where I start. I see, the court order, the terms. Are they there? Are they specified? Is it specific? Is it, pick up to be at the Walmart at 7 o'clock? And a lot of times I can see where it just says to meet in a mutually midway point. It's just so before you say someone is in contempt, before you can ask the judge to do that and pay out attorney fees for which you won't get reimbursed, you need to make sure that those terms are in the order and that even before the initial order is finalized, that it's very specific to your circumstances. So if you've already, before you have a final order, someone who just doesn't comply or someone who, is manipulative, make sure you have those specific terms in there to lock them in. That's the very first error I see, Jerrad, with these contempt proceedings. Another one is that you just lack the evidence that the person's behavior is willful, that it's deliberate, that they are intentionally not complying with the order. That must be a state of mind. And so if you're not having evidence of that, then the court cannot find that person in civil or criminal contempt. Another error I've seen, and I was just able to get out of a case with this 2 weeks ago, was before we start the proceeding, you need to specify to the court and have it on record that we are proceeding in civil contempt or criminal contempt. We went through a whole proceeding and had not been specified. And as soon as it was time for closing, I asked for motion to dismiss because we didn't even know if the court was to find the person in civil or criminal, because a person cannot be found in both civil and criminal for the same violation. And again, as I've already stated at the beginning, there are different burdens for civil versus criminal contempt. And so there's a lot of case law here in North Carolina where it must be specified and everyone must know which type of contempt we are proceeding on before you even start your hearing. Another error that I see is that for whatever reason, you don't have the evidence to show that that party can comply with the order, right? Because again, that is an element of contempt, that the person has the ability to comply, but they are not. So maybe you did not issue the discovery request, right, to show their finances. When I say finances, bank statements, credit card statements to show how they spend. You don't have the evidence of their monthly, just living expenses. Did you get evidence that third parties help them pay for these expenses, especially when someone says, I can't pay that alimony or I can't pay that child support? Just being able to prove to the court that, no, that's not true. They have the ability to comply with the order. Again, that's just a common mistake that I've seen. Going in without legal representation is huge. You should always go in with a contempt proceeding with an attorney. And I'm not for sure in other states, but in North Carolina, if you are the person who's been accused of being in noncompliance with a court order, you are afforded legal representation by court-appointed counsel. But if you are the one trying to pursue the contempt, you need legal representation. A way to avoid a person who is in willful, deliberate, intentional contempt is for me to use a strategy of filing a cross contempt against that party. So you have people filing for contempt and they don't have what we call clean hands, right? And so when both parties are faced with contempt, what do we want to do? We'll just dismiss it. And so when you proceed on a contempt, you need to have clean hands. These are just some of the errors that repeatedly are seen in people being unsuccessful with contempt actions, which is just, it can be avoided, especially, if you're like you've already said, look, I don't have enough money to do the contempt. Okay, I'm going to try it. And then, maybe I can get some of my attorney fees. But if you don't even give yourself a chance for that, that's absolutely horrible. So again, those are just some of the ways that I've seen contempt just not be successful after it's filed.
Yeah, to touch on a couple of things that you've already touched on. So the poorly written orders, that kind of goes back to the underlying matter, right? The divorce or the custody case, where I know sometimes the clients will get frustrated with the amount of time taken to draft these orders or the cost associated with these orders. And it's like, hey, look, let's get it right now. Let's be very specific. We don't want anything that's vague. Because if it's not great and it's vague, we're going to have to go back to court, and it's going to cost you double of what it would have cost to get it right the first time. So, not really talking about contempt there, but it's like, look, get the order right the first time, and so we don't have to deal with it later. And then also, I liked how you talked about making sure you have legal representation, because a lot of courts, certain family law things, they kind of let a lot go. It can be informal, but when it comes to contempt, it's pretty formal. There's jail time is on the line, right? And so I found courts have been very by the book. So it's very important attorneys are involved to ensure the process and procedures are followed to be successful, or just to be appropriately heard. Because a lot of times without legal representation, things aren't filed right, and the procedure won't even start. So it's just important to make sure those things are done correctly, particularly in a contempt action. So, well, thank you, Bennita. That's it for today. As a reminder, to set up a consult with us, a virtual consultation, 866-DADS-LAW, or visit our website, CordellCordell.com. Thank you.